Just take up my Lord Justice Arnold's point about the cross-examination of Mr. Abbey. Can I just draw your attention to the following passages, which are just before the ones we looked at, which is, it's page 819 of Divider 164 of Supplementary 4. And I would draw your attention to internal page 92 at lines 4 to 12, and 92 at lines 4 to 12.
Sorry, can we just?
I'm sorry.
So we're page 92, lines.
Page 819, internal page 92, lines 5 to 12, and then.
And we're dealing with the November meeting.
That's right. And then internal page 94, just across at lines 9 to 18. Now, my Lord, my submission, it puts the gist of the case. You might think that certain other people might cross-examine much more robustly, but then there's different styles of cross-examination, and each has their place.
Well, of course there are different styles of cross-examination. Of course, you don't have to put it to a witness in terms that they are lying. But nevertheless, I repeat my earlier question. Can you point to any passage in this cross-examination where it is put to the witness that what the witness said in paragraph 9 of his statement was incorrect?
Not in so many words, no.
Thank you.
What I'd now like to do is deal with contemporaneous documents, because they show, there's two things we say. One, it shows that C1's a liar, and two, it shows that contemporaneously he was holding himself out as acting on behalf of the Dewsbury Trust. And it goes to the point that we were discussing before lunch as to when C1 decides that the land is to go into his name as opposed to the Dewsbury Trust. Can I start by looking at, we're dealing with the correspondence with four sides, the solicitors. Now, it's not a dispute that C1 was dealing with the fundraising and was deputed to deal with the solicitors. And if you go to Supplemental Bundle 1, page 30, Divider 35, 283.
I think I've got to the wrong place. What was
it's bundle Supplemental 1.
Yes.
Divider 35, page 283.
Yes.
This is a letter from Mr. Isaacs, who was the solicitor at Four Sides, who was directly instructed by C1. And he writes to the agent, selling agent of the property, Dear Mr. Cluckham, Abbey Mills, Stratford, RTZ Estates. Thank you for your letter dated 13th February. We've since spoken, confirmed with instructions to deal with the contract documentation proceeded, number of inquiries relative. Mr. Okai now wishes the purchase to proceed in the name of Anjuman Islam and Muslim of UK of 911 Christmas Street, London 1. This is the largest of the Muslim charities.
Sorry, can you explain to me, who is Mr. Okai?
We think it's a made-up name for C1.
Okay, understood, thank you.
I'll take it to he made up another name.
Yes, I remember that from
yes.
the judge.
This is the largest of the Muslim charities, and their bank is the National Westminster Bank PLC Ship House, Battersea Square, London. You're welcome to write to reference to both the chairman of the charity itself and their bank. So this instructions must have come from C1 that he's acting on behalf of Dewsbury. Either the solicitors are lying, or he is, or, as we say, Occam's razor, he's telling the truth. And if we then go to subsequent correspondence from Forsyths to C1, and that's in Supplemental Bundle 2, one starts, there's Divider 45 at 301, This is a letter from C1 to Forsyth, divider 45301. And you see again, it's on the headed note paper of the Dewsbury Trust. And the same goes for the letter at 46. And 48. And 55. So he's instructing the solicitors clearly on the headed note, the headed paper of the Dewsbury Trust. And if one then goes to '49, this is a letter from Forsyth's to Mr. Mohammed slightly earlier, re Abbey Mills. And third paragraph, it seems our one remaining problem is VAT. What problem it is, you observe the RTZ tax department take the view they must charge VAT. I have told them time and again you cannot pay VAT because you cannot recover it and you are in any event a registered charity. Of course, the London Trust was not then, and not for many years a registered charity. And then, if you go back on the page 310, it's a letter to Apothecary and Barrett, who I think solicitors acting for RTZ. Thank you for the letter, 30th. We've passed everything to our clients. There remains a very difficult problem. Our clients cannot pay VAT because they can't recover it. They are a registered charity and so they are not liable for VAT. That can only be a reference to the Dewsbury Trust. But the judge, if one goes to, deals with these at paragraphs 103 and 104 of his judgment, core bundle divider 10.165. He says at paragraph 104, that he doesn't regard as good evidence of the understanding of C1 secured work to trust, as the trust on behalf of which they regard as acting. I do regard as evidence of willingness to mislead third parties as far as might convenient, perhaps. Well, either way, it's dishonest. Either way, if he's right, either he's against the Occam's razor point. If you believe what he says about the 1994 meeting, he is lying to his solicitors at that stage, telling them untruths and falsely representing the position. Or he's either correctly...
He recognises that in the last sentence.
Well,
because we know that he condemns the first claimant elsewhere in the judgment as having given untrue evidence.
Yes. Well, I'm coming to that, but this is holding out as well. It's just, it sets the Occam's razor point. There comes a time when you cease, or the judge ought to stand back and stop making excuses for the first claimant, actually come to the conclusion that the evidence he gave it on oath at trial was false, and that the documentary evidence which we see at or near the relevant time was correct. The NatWest bank account was opened in Dewsbury's name. The judge found that, and that's right. We would submit. And if I've already drawn your attention to the cheque that was addressed to the Dewsbury Trust, £104,000 cheque, which is at page 209, Sub 1, divider 21, page 208 rather. That was addressed to the Dewsbury Trust at the account. There is one other point I'd make on the solicitor's correspondence, if you go to, we're in Supplemental Bundle 2, Divider 71, at page 369. And this is a letter from Chadwick Lawrence, who were instructed by the Dewsbury trustees to Forsyths in November 1996. I act on behalf of the trustees of the Anjuman Islam Muslimin of UK South Sea, Savile Town, Dewsbury, West Yorkshire, who provided the purchase money in respect of the above property. Clear assertion to Forsyths. And then if you go on to 372, which is...
Well, but is it true? Because this is a statement, as I read it, that the trustees provided the purchase money. The who must be a reference back to the trustees, but they didn't on any of you.
Well,
even you don't say that.
No, but the money was collected. We say the money was collected on our behalf. That's what I mean. That's what I think it means. No one's saying that the trustees...
Is there any evidence of a transfer from trustees to the purchasers of the property?
There is evidence of £100,000 came from the Dewsbury Trust bank account to...
Yeah, but the judge didn't accept that.
No, it's in 97. He didn't accept that it was for the purchase of that. I think the answer was it was used to defray loans or repay loans. But there are things too. I think there's a subsequent £45,000 sent. But there's no... We don't deny that the money for the purchase of the land was paid into from the donors, the account you've seen, and was paid out of that account. And the account happened to be in the name of the Dewsbury Trust. So, with respect, my lord, I don't...
But not in the name of the trustees of the Dewsbury Trust.
Well, the trustee...
I think you're accepting that.
Yes.
Of course, you're entitled to make the point which you've made, which is the money that it did come out of, the account it did come out of, was an account in the name of the Dewsbury Trust. Fine. But it comes back to the central question of who are the trustees? Because the account the money came out of was not in the name of the trustees of the Dewsbury Trust. So if one thinks about it in terms of legal title, it didn't come from a source, the legal title to which was those trustees.
My lord, I would submit that if you have a bank account that's open in the name of a trust, who has and can only act through the trustees...
Well, exactly,
it's
which is why you need to know who the trustees are.
Yes, but, well, it's clear, the trustees of the Dewsbury Trust, that's what they're saying. I don't think my submission, there's nothing inaccurate or sophistry there, it's not inaccurate. The clear assertion is that the money used to purchase the property came from Dewsbury. Whether it's the trustees or a bank account in the name of the trust, who can only act through the trustees.
All right.
There may be a legal difference between, on the one hand, the trust and on the other, the trustees. I mean, the same way as there's a partnership doesn't exist, say, through the partners. But there may be a difference. A trust could technically act and it's different from the trustees of the trust. But as far as that letter is concerned, I accept a letter from firm solicitors. There's nothing, I would say, improper and inaccurate. It's clear what's being asserted. And the point back, I suppose, to my point is 372, which is a letter over a month later from Forsyths. And he says, first of all, please accept my apologies for delay in responding to your letter. I wanted to check the whole situation, so let's remove my structure of confidence, of course, being secretary of the association. And the point is, there is no assertion there, as one might expect. Oh, no. The money didn't come from the trustees. What on earth are you talking about? It came from a wholly separate, it was given to a wholly separate trust.
It is a bit muddy. I mean, taking this letter first, he, of course, being the secretary of the association. Well, what association was he secretary of?
In C1's own mind.
And that sort of ties in with paragraph 108, where the judge is dealing with the bank account. because the bank was provided with a signed certificate. A resolution had been passed and entered in the minute book that the bank should have the appropriate authority to accept instructions on the signatures of D14 and C2, acting respectively as chairman and treasurer. Well, was C2 treasurer?
Not that I've seen. I mean, C2 didn't give evidence, nor did D14, of course.
He wasn't a trustee of Dewsbury at all, was he?
No.
So he certainly wasn't treasurer of Dewsbury.
No. But I don't know whether C2 has ever, because remember, at this time, the 1996 deed didn't exist. And I'm not sure whether it's ever said that C2 was ever appointed as trustee or treasurer of the London charity, which didn't actually register itself until 2018. It's all just untruths, half-truths and lies from C1. Divided that same money, if one looks at, I've dealt with the NatWest Bank account. Well, actually, it's worth doing it. Can I get you back to supplemental bundle 1, please? That might just sit. If you look at it's divider 32. It's letter 23rd January 1995. It's addressed to D14 from the NatWest Bank, and it's addressed to D14 at the Dewsbury charity. If one then looks over the page at 281, this is where you might get chairman treasurer from. This is the document referred to by the judge. The meeting of the Committee of Management of the UK Assessment of UK, 1st February 1995. They purport Mr. D14 says he's chairman, C2 says he's treasurer, and then one gets the letter at 7th of February at 282, again addressed to D14 at the Dewsbury charity.
I assume, for what it's worth, that no resolution was entered in the minute book of Dewsbury.
No, it's completely false.
There's no connection between any trustee of Dewsbury apart from D14 in the opening of the bank account?
Well, I mean, the case at our case at trial was that they were effectively acting as our agents.
Sorry,
the judge didn't accept.
There's no document
No.
identifying a link between
No.
the trustees.
No. But I mean, and I accept. Look, this is all the donees. These are the people collecting the donations. Technically, as I've said, it's the intention of the donors that count. But if the key evidence is that of D14 and C1 rather, then he has been a party to contemporaneous documents which clearly tend to the opposite conclusion, that he was acting for...
In some respects, undoubtedly, but just pursuing the point my Lord Justice Newey was making, when we see in the mandate Mr. Zulfikar Ali described as chairman, he wasn't a chairman of Dewsbury Trust, was he?
No, he wasn't. He was a trustee of Dewsbury Trust. And nor was C2 trustee or treasurer of that.
In fact, he wasn't even a trustee.
No, he wasn't. No. So
both those statements are inaccurate.
Yes, they are.
If intended to apply to Dewsbury Trust.
Yes, they are.
Yeah.
Yes, they are. can I then ask you to look at page supplemental 2, divider 39, page 295. And this is a letter to the estate, to the agent, Grimley International, and you'll see it says, second part, the interest of our charity is to purchase this land in order to develop a community centre comprising a single building hall which would cater for the needs of our local community. And the bank has had to provide a reference, and then it's signed Zaid Ali on behalf of the Anjuman Islamic Muslimin UK, 911 Christian Street. So that's again the Dewsbury Trust.
Except that, as you've conceded, he wasn't chairman, which is how he is described here.
Yes. Oh, no. But it's not saying, we're on behalf of the new trust, where we're intending to set up a new trust, and we've been authorised to collect money on their behalf.
No, it certainly doesn't say that, you're right.
Can I ask you to look at, while we're there, divider 76 of that bundle? And this is the claim you'll have seen mentioned for business rates removal. This is after the contract, and this is a document signed by C1. Um, 26 February 97, Deputy Chief Executive and Director of Finance, Newham Town Hall, rate demand, further rate demand, would you please note the following? 1. The new owners of Abbey Mills Riverine Centre, a registered charity who took possession of site 5th November, building premises sites fully vacant except for security staff. So again, although he's calling it the Riverine Centre.
Was there any evidence as to what that expression meant at that particular point in time? Because, I mean, it's not a... I mean, was it, to what extent was it in currency at all?
I think there's a number of documents by which it's titled in that the Riverine Centre. It's not how it's registered, and it's not a reference to any particular charity, I don't think. If you look then at divider 82...
So he's saying, on one view, that a non-existent entity is a registered charity.
Yes, well, the only registered charity was the Dewsbury Trust.
Well, indeed, but he doesn't refer to the Dewsbury Trust.
No,
he refers to something called the Abbey Mills Riverine Centre, which was not an entity which existed.
Well, unless you're going to describe the land itself as the Abbey Mills Riverine Centre, and not the charity.
Well, he's referring to the owner of the land.
Well, perhaps to put it in context, if you go to divider 82, this is the application for relief from business rates to Newham. Section A, name of the title of charity organised, Anjuman Islamic Muslimin of UK. That can only be description of the property relief. So Abbey Mills, Stratford 15, and then Section B, mandatory relief, registered charities only. What are the objects of charity? Mosque of religious activities, approximately 1980 Liverpool. And then it gives Mr. Daji's address at the Dewsbury Mosque. Please state, over the page at the top, please state the registration number of the organisation, and that's the Dewsbury charity.
And it's signed by Mr. Daji, is that right?
That's right. So,
and was it Mr. Daji who filled it in?
I don't know. I'll have to take instructions on that. But it clearly relates to the property, and it's an assertion that it's owned for business rates relief by the Dewsbury Trust. You might see that a reference, just looking at it, if you go to page 84, divider 84, there is a document headed Abbey M Riverine Centre. So it was a name, a title that was current at that time.
Oh, so they got as far as having a letterhead.
Yes.
But the letterhead doesn't give the Dewsbury address.
No, it doesn't. If you go to dividers 88 and 89 in that bundle, please.
But sorry, I mean, can I come back to 84? Is it your case that when we see printed letterhead headed Abbey M Riverine Centre, Canning Road, London, E15, that is upon a correct analysis, a reference to the Dewsbury Trust?
No, it's we didn't fully understand that. It's a reference, we think, to the land itself. There's no register. There's no charity. They don't purport to call. Because remember, on their case, by November 1996, they've already entered into the deed of trust, calling itself the London Brackets Trust. So it may be a description, a geographical description of the property, but it doesn't purport to be, and I'm not sure it's ever suggested that there was a trust or charity called the Abbey M Riverine Centre. It's most likely a description of the geographical site.
Am I right in understanding that at that point in time there was no building on the land, or was there a building on the land?
There was no building on the land. There still isn't a building on the land.
As one can understand the word centre being used to refer to a building, it's a little more difficult to understand it being used to refer to a vacant plot of land.
I think so. I don't, off the top of my head, know when any structure that's on there was constructed. As I understand, that there has only for 2 years been planning permission to use it as a mosque. It's a site of a former factory, and it may well be at that time there was no structure on the land. Whether one has been built subsequent, I don't know.
Okay, sorry, which one was next?
I was going to take you to divider 88. And this is all to do with the expressed willingness of C1 to transfer the land, the actual title to the land, to the formal trustees of the Dewsbury Trust. And this is a letter 18 June 1997 to Mr. Tyne Chadwick from Mr. Isaacs at Forsyths. Some of your clients are concerned the property has not yet been transferred to the names of 4 nominated trustees. Please be so kind as to assure them. And if you go to 401, which is at divider 89, you will see again, dear Mr. Tyne, very edited June, now enclosing copies of the email transfer. So there was a stage where C1 expressed a willingness. Indeed, he had signed documents, or subsequently signed documents. If you go to divider 105 at that bundle, there are a number of documents, but there are 105 at page 447, that's a document signed by C1, which acknowledges that he holds the property on trust for Dewsbury. And at 108.457 is a document signed some months later to the same effect. And if you go back to 92, that's a letter dated 10th of October 1997 from Argylls and Court solicitors to Mr. Mohammed, read the Abbey Mills project, are reporting to the legal aspects of the contamination of the above site. And then the report is at the next divider, and you can see it's addressed to the Anjuman Islah ul Muslimin of UK, the heading, and then page 413, it says, introduction, as we about UK, we've subscribed a copy of the Society's Constitution, search the Charities Registry, Anjuman Islah the Madrasa Islam, charity registration number 505. So, court talks of view the existing constitution.
Pardon, where are you now?
I'm at 413, my lord. It's just after Part A report.
Thank you.
Now, given the judge's, A, it's clearly the Dewsbury Trust. 2, given the judge's finding that the 1996 trust didn't come into existence until sometime in July 1998, the constitution that they have been showed cannot be the 1996 trust. One could speculate that it's in fact the 1975 trust, but one doesn't know. Now, my lords, in respect of that, I accept that these post-date the acquisition of the property and a large part of the fundraising. Secondly, they're evidence of what the donee thought and not the donors. And I suspect also they could sound to you like closing submissions at the trial and not submissions on an appeal. But the point is this, that if one discounts the key part of the evidence, the oral evidence given by C1 at trial, we would submit that the evidence that these sums were raised on behalf of the Dewsbury Trust is overwhelming. It's the Occam's razor point. As I've said, you have to then, if you believe what C1 says in November 1994, you then have to discount all these subsequent documents where he and others hold themselves out as acting on behalf of the Dewsbury Trust. I'm then going to turn now very briefly to, it's fairly obvious C1 was a dishonest witness. As I said, he purported to give detailed evidence of a meeting that took place 28 years before he gave evidence. There was no documentary evidence of that meeting, nothing to remind him. As I said, it was never previously mentioned prior to his witness statement in January 2023. C1 was a highly partial witness. He had immense self-interest in giving evidence helpful to his side of the case, and therefore whether wittingly or consciously or unconsciously, his evidence, if one applies Guessman or looks at what Guessman says, it's likely to have been coloured by the attitude or his position in the case, particularly after the schism.
Well, if you're right in your first submission that he's a dishonest witness, you don't need that point, because that point is directed to people who persuaded themselves mistakenly that what they're saying is the truth.
Yes, but I don't think, well, it's not my submission that C1 persuaded himself unconsciously. He persuaded himself consciously and sought to successfully persuade the judge. As I say, I've already made the point on plausible. That in one way, plausibility is not the test. I suspect it might be relevant, it's credibility, but in the evidence it was too plausible. It was too detailed, too helpful to his case, and the judge says, hold on, this is a meeting 28 years ago. And elsewhere in his evidence, we've taken one point, C1 does say, well, it's a long time ago, I can't remember. On a number of occasions, if you look at day 5, I won't take you to it, but page 409, 432 and 447, he's asked about certain events which post-date the November 1994 meeting, and he says, oh, I can't remember, it's such a long time ago, 30 years. And indeed, in paragraphs 4 and 6 of his own witness statement, he makes the point himself. And the judge was rightly critical of him in a number of respects. We've seen those already. But so he backdated the 1996 deed and swore blind that he didn't. He gave an excuse for failing to register the London Trust, which the judge didn't accept rightfully, particularly as he's an accountant. He falsely used, by his own admission, the name of the Dewsbury Trust, if he's right, and he used a false name unashamedly again in business, and that was, the judge notes that. So I accept that the judge got most of that. He accepts that. But there comes a point when you stop having to make excuses, having said why, well, I believe what he said in 1994, all the rest of the stuff I'm going to disregard or I'm going to make excuses for. Comes a point when the judge has to stand back and say, well, hold on a minute. This is contemporary or near contemporaneous documents, which are not said to be forgeries. They are directly contrary to what he has told me on oath. The easy explanation, the simple explanation, is he's lying on oath and the contemporaneous documents are weak. And it's not true, it's not the case we would submit. The judge said he wasn't cross-examined on the point. He wasn't cross-examined that there wasn't a meeting in or around November 1994, but he was clearly cross-examined on the basis that there was no trust and he wasn't authorised to act on behalf of a new trust.
Just pursuing that one moment.
Again, was it put in his evidence that 3 individuals were appointed at that meeting or identified at that meeting? Was it put to him that that was false?
Not so many. Well, I'll direct you to it.
Or even just incorrect?
Well, it was put to him repeatedly that he wasn't telling. Well, it wasn't the case that there was a new trust. It wasn't the case that it was anything different. If you go to, for example, let's look at it. Sorry, my Lord of Justice.
I think I was in the same territory. I was pulling up Mr. Mohammed's witness statement where he says, for example, it was decided at the meeting that the land should be bought in the name of the 3 trustees and they will run the charity for the London community. So were things like that subject to challenge?
Yes, my submission they were. Can we go to day 2, which is at 165. .854. This is the bit where it's, if you look at it, it's 2299 to 230, which quizzed about the notes.
2229.
Yeah, it's 2299 to 23021.
Shall we just read that?
Yes, but look at what's put at 230, line 7. I will be saying it is surprising that you have such a seemingly precise recollection of events that were over 30 years ago. And I will be submitting this is something that will affect the weight that should be given to your evidence.
Well,
where is it? That's not putting it to the witness that the evidence is false, is it?
No, not so many words, but can I take you further, please? You go to 860, internal page 252. At page 4, line 14, Mr. Westman. Thank you, my lord. I'm also going to suggest to you, Mr. Mohammed.
I'm sorry, I haven't found the right page.
I'm sorry, it's 860.
Yeah. Sorry, which of the transcript pages?
It's internal 252, my lord.
Thank you.
13. Yeah, 14. Mr. West, thank you, my lord. I'm going to suggest to you, Mr. Mohammed, when the donors paid money into NatWest account, they had no reason to believe that it would be going towards anyone other than Charity 505 said, did they? Do you accept that? No. Most of the donors asked, is it for London? We gave them the number.
But what's that got to do with the question about the trustees? Because it's a conclusory question, isn't it? Whereas what I'm interested in, was he challenged on this statement about the three individuals being the people who are going
I need to take you to a number of passages.
Well,
as I said,
it would be very easy if he was challenged, because he would take me to a question that said, when you say in paragraph 5.14, your statement, these three individuals were agreed to purchase the land, that was untrue.
That was not put in that many words, no. It might have been the way I would put it if I was cross-examining, but I wasn't cross-examining. But as I said, there's many different styles of cross-examining.
Yes, but you see, you're submitting that what the judge said is wrong.
Yes.
And at the moment, on this particular point, as to whether the witness was adequately challenged, and that's why I'm asking the questions, because if you say that the judge is wrong to state that the witness wasn't challenged on these key points, you have to show that he was challenged.
Well, I'm trying to. I accept there's no individual question, but what I'm trying to do is show you the burden of the cross-examination was there.
But it wasn't, I mean, leave aside the reference to a paragraph number. It wasn't said to Mr. Mohammed, it isn't in fact the case that at the November meeting 3 trustees were chosen.
Not in so many words. I'm trying to take you to the bulk of the cross, because it was done in a different way, in a different style. And my submission, the cross-examiner, is not to be criticised for not going the direct route which some of us might have done. I'm at 252. I was going to go to internal page 262. And it's 262 line 21. What I'm going to suggest to you, Mr. Mohammed, is that there is no suggestion that the donors wanted an entirely new organisation to be established. Answer, they would never give us a penny if they understand that this is not for the new purchase of land. Question, I'm going to suggest to you that donors were giving the money to the existing Tablighi Jamaat movement on the basis the property would be held by 50572. Do you accept that? No. That's it. It seems to me, well, my submission, that would be a challenge to the assertion that there was to be a new charity. And if I go to page 273, at line 11, question, did you tell those who had donated money towards the purchase that you had set up a new independent London charity? Answer, there was no need to tell them. But how many donors? We have thousands. Question, on the basis of saying that there was no need to tell them, can I take it the answer to that question is you did not tell them? Answer, we told them, but those people having reservation that only for London, they knew we had totally new setup. Question, how did they know you had totally new setup? Answer, we told them. And when did you tell them? Whenever when they asked, what did you tell them? I tell them we have totally new setup of trust declaration deed, and it's in the same name. When we bring the checks of other things to the nation, they have a separate entity. Did you tell them this new charity was completely independent of Dewsbury? Yes. Did you ever put that in writing? We did not put it in writing. And the question I'm going to suggest to Mr. Hammond is you did nothing of the sort. You did not tell them it was independent of Dewsbury. Do you accept that? No. And you did not tell them that you would set up a new independent charity. Do you accept that? No. And can I ask, if you go to, this is day 5, which is internal page 407.
Mr. Mohammed must have been in the witness box a long time.
No, I think he popped in and popped out.
I see.
There were various witnesses in. I think he had spent 3
Yes, I see.
3 intervals in the witness box. This is internal page 407, bundle 895. Line 10. Question. That's because Mr. Patel, I suggest to you, it was always intended that you first came to the 14th event would hold Abbey Mills Trust for Dewsbury. Do you accept that? No.
Sorry, I wasn't keeping up. Oh, I see, yes.
That had been understood by the time you purchased 96. Answer, never. And the London community had not been told anything different, had it? A London community knows very well.
Sorry, I'm sure I'm being very slow here, but I'm confused. Who is Mr. Patel?
I think that's a mistake. This is the cross-examination of Mr. Mohammed. It's not suggested otherwise.
But there's two references to Mr. Patel at 406.
Well, it's not a cross-examination of Mr. Patel. It's the cross-examination of Mr. Mohammed.
Right. Okay.
So maybe because Mr. Westwood had been referring to Mr. Patel for a different purpose, he then...
Right, okay, thank you.
And if I go then just for internal page 437, and I'll start at 436 at 21. It's 902. Mr. Westwood, quite my lord, I'm going to move on. It's not the reality, Mr. Mohammed. This document, the Declaration of Trust, does not date from 1996 at all. It is 96. And you drew the document up a much later date in order to create the impression it had been a separate charity established at the time of the Abbey Mills was bought. Did you not? No. Sisters needed on time of completion to give it to the land registry. And you then backdated the time of the document. I did not backdate it. There's a solicitor's signature. Also, we signed it and sent it back to us. We kept it. You did not tell Dewsbury about this separate Declaration of Trust before these proceedings began, did you? Why did I tell them for? We independent trusts knew everything that was going on. After 30 years, we don't have any knowledge. Everybody knows in the society we have a separate London trust, and they bought this place and that's what it is. What I'm going to suggest to you, Mr. Mohammed, is that your version of events about a separate London charity has been constructed in order to try to claim the Abbey Mills site, which has been intended to be held in trust for Dewsbury. Do you accept that? No. So, perhaps not in so many words, my submission to the case was clearly put that there was no and never was any separate London charity. I know at the time, my lord, I'm going very quickly to give you references. I'm sorry, because we don't really have time. I don't want to trespass on my learned friend's time, but if you look at my learned friend's closing submissions, again, this is to deal with the island hopping point. It is said, we are inviting you in the graphic words of Lord Justice Lewis to island hop and not look at the sea of evidence. If you look at his closing submissions, paragraphs 38 to 49 are the paragraphs that set out the evidence which he relied upon or invited the judge to rely upon. In addition to the first claim, there are a number of witnesses who are referred to, and I'm going to give you just a reference because my overarching submission is that none of them give any evidence that it was intended to be a separate trust. Some of them give evidence that the money was to go to for the purchase of the land. That's fair enough. We accept that, but that doesn't come anywhere near establishing that there's to be a separate trust. And paragraph 40 gives the evidence relies on Mr. Cadwallader. That's paragraphs 6 and 7 of his statement. I'll give you the references, I'm not going to take you to. Supplemental Bundle 1, Divider 7, 79. Paragraph 41 of the submissions cites the evidence of Mr. Y.A. Mohammed. Paragraph 5, Supplemental 1, Divider 8, page 84. Both of those are mentioned by the judge at paragraph 79 of his judgment. Paragraph 41 cites the evidence of Dr. Howlander. That's Supplemental 4, Divider 170 at 982. He gives evidence quite the opposite. Paragraph 42, Mr. Rahman and Mr. Chowdhury Rahman is paragraph 8, Supplemental 1, 18182. And Mr. Chowdhury is paragraph 7, Supplemental 1, 12139. There is reference in paragraphs 43 and 44 to the evidence of Mr. Shabir Daji. He was one of our witnesses. And there's various references to him. He does not give any evidence to the effect that there was to be a separate trust. Paragraph 45 cites Mr. Dudat, which is transcript day 4, page 340, which is supplemental 4, 167, page 880. And he didn't recall the November 94 meeting. Paragraph 9. I'd say I'm doing this to avoid the island hopping thing. I'm just if I'm saying I'm asking you to ignore the sea of evidence and island hop, I'm drawing your attention to the sea of evidence, and none of it backs up what C1 and to a lesser extent Mr. Brown had to say. Paragraph 45, the evidence, Mr. Javed Malik. That's transcript day 4, page 355, lines 16 to 18. That's supplemental 4, 167, 884. Paragraph 45 also refers to the evidence of Mr. Islam, Nurul Islam, day 7, page 722. It says 733, but that's a typo. It's supplemental 4, divider 1770, page 974. Paragraph 945 refers to the evidence of Mr. M.K. Raman. That's transcript day 7, page 735, lines 11 to 14. Supplemental 4, 170, 978. Paragraph 46 refers to the evidence of Mr. Javed Malik. Transcript day 4, page 356, lines 7 to 15, which is supplemental 4, 167, 884. Paragraph 48 cites the evidence of Mr. Cadwallader. Transcript day 1, page 115, line 17. It's page 116, line 16. And that's supplemental 4, 167, 824. Paragraph 48 cites the evidence of Mr. Malji. That's his witness statement, paragraph 17 to 18. Supplemental 1, divider 6, 71.
Sorry, supplemental 1, divider
6, page 71.
Yep.
Paragraph 49 cites the evidence of Mr. Javed Malik. Transcript day 4, page 356, lines 7 to 17. Supplemental 4, divider 167, 884. Nearly finished, my lords, I'm sorry. Paragraph 49 cites the evidence of Mr. Cadwallader again. Witness statement, paragraph 9. Supplemental 1, divider 7, page 80. And finally, paragraph 49 cites the evidence of Mr. Akil Lone. Witness statement, paragraph 5. Supplemental 1, 9, divider 9, page 88. I accept that's just a long list, but what I say is this, and we are specifically accused of a classic case of island hopping. I've given you there all the references to the evidence that my learned friends relied upon at trial, and none of it, apart from the evidence of C1, supports the case that there was a separate trust to be established. And the highest the oral evidence can be put is that the donors were keen, in fact insisted that the money be collected, go to London, and for the purchase of the London land. It was a bigger mosque for them, for the London community. And none of that supports any sort of assertion that the donors intended the money to go to a wholly new trust, which they trusted C1, C2 and D14 to establish. And finally, there was evidence to the contrary. There was evidence from witnesses recall that they thought the money was going to Dewsbury. And again, I'll give you those references. Mr. Udin, paragraph 3 and 4, supplemental 1, 19188. Mr. Hazel Mia.
Sorry, supplemental 1.
Supplemental 1, divider 19.
Yes.
188.
Yes.
Mr. Hazel Mia, paragraphs 3 to 6 of his witness statement. Supplemental 1, divider 15, 161 to 2. Mr. Bostan Mohammed, paragraph 11. Supplemental 1, divider 11, page 131. Dr. Hollander, we've already seen his cross-examination about the receipt, but paragraph 7, supplemental 1, divider 20, 196. Mr. Aulad Ali, paragraph 6 to 8, supplemental 1, divider 14, page 155. Mr. K. Raman, paragraphs 5 to 7, supplemental 1, divider 18, page 182. And Mr. M.Z. Haq, paragraphs 3 to 6 of his witness statement, supplemental 1, divider 16, page 168 to 169. Now, my lord, again, I accept one could be saying, well, oh, Mr. Holland, these are your closing submissions at the trial. But the point is this, that the sea of evidence does not lead you, consideration of the sea of evidence does not lead you to say there was evidence that the judge could rely upon which he hasn't cited. The judge clearly relies on the evidence of C1, and there's little other evidence to support the specific assertion made by C1 that he was to be the trustee of a wholly owned trust. There was evidence to the contrary, that those people that gave the evidence I've just given thought they were donating to the Dewsbury Trust. And the judge, I accept that he implicitly rejects that evidence, but he doesn't fully resubmit and adequately explain why he rejects that evidence. And the truth is, the judge simply focused on the November 1994 meeting and thereafter rejected or sought to excuse away any evidence that was contrary to that finding. What he should have done was stand back and look at the totality of the evidence. And if he'd done that, could not have found that the first claimant was telling the truth when he gave his account of the 1994 meeting. My lords, those are my submissions.
I don't detect any more questions, so thank you very much, Mr. Holland. Mr. Seft.
My lords, if I may, I want to structure my submissions in 4 parts. But first, I want to touch on the authorities on appeals on fact. Second, I want to identify precisely what the competing positions were at the trial, because I say they've not been presented in a way that is accurate to this court. Third, I want to survey the evidence that was before the judge and how he dealt with certain key areas of it. Because, much as Mr. Holland protests he's not island hopping is exactly what he's doing. There are great swathes of the evidence, of which not a single mention has been made, that were absolutely key to how the judge came to his conclusions. Telling you that he's shown you all the references to the November 1994 meeting is not addressing the sea of evidence. That's walking round around one particular island in the sea. And then finally, my lords, I will address the 3 grounds of appeal to the extent that they've not been already covered. But I expect to have covered most of it by that point. So far as the authorities on appeals on fact are concerned, I sense you won't be helped by being taken to them. So I will just give you the paragraphs on which I particularly rely. In chronological order, Datek, paragraph 12, that's Lord Walker's dubitante. McGrady.
Sorry, Datek, paragraph 12.
Yes.
Yep.
McGrady, paragraphs 2 to 4. And the point I stress from those is the point made there that the judge lives through the trial. And when you live through the trial, you hear day after day of evidence. You gain a familiarity and also an insight into that evidence that isn't really available to this court. Phage, or as I've always called it, I now know to call it fire, the famous paragraphs 114 and 115. Can I ask you also to go to 117, where Lord Justice Thurston stresses the importance of reading the judgment against the background of what the dispute was. Volpe, paragraph 2, and also paragraph 65. That's all I would say about those. So, the second section, what is it the judge was dealing with here? Could I ask you to take up the core bundle, tab 3, page 40. Could I ask if this is the appellant skeleton? Can I just ask you to remind yourselves what Mr. Loveday says here at paragraph 6 to 9. There are 2 points I want to make about this description of the question for the judge and the issue before him. The first concerns the nature of the Tablighi Jamaat movement, and the second concerns the way the dispute is described in paragraphs 8 and 9. Now, so far as the Tablighi Jamaat movement is concerned, he says in paragraph 7 that it had its national headquarters in Dewsbury. There's a reference there to paragraph 46 of the judgment. And if you then go on to page 49 of this bundle, paragraph 53.1 of the skeleton, line 3 of paragraph 53.1, you'll see he says, it was and is the LBMW defendant's case that Tablighi Jamaat in London was not legally distinct from the overarching national institution. Fundraisers were not London trustees, but responsible local figures within the Dewsbury Trust. Now, Lords, the question whether the Dewsbury Trust was an overarching national institution for the Tablighi Jamaat movement in the UK was a fundamental issue that divided the parties at trial. I will come back to the evidence on this, but our case was this. It was not an overarching national institution. That in legal and financial terms, local communities of followers around the country operated quite independently of the Dewsbury Trust. They ran their own finances, they owned their own properties. That Dewsbury had a significance as a place. The reason it had a significance as a place is because there were elders in the movement, especially a man called Hafiz Patel, and he and other senior elders were based in Dewsbury, South Yorkshire. And within Islam in general, but also within Tablighi Jamaat in particular, there is a cultural and religious expedient to show respect to your elders. And what that meant in practice was that there was a religious expedient to consult on practical matters, not just religious matters. And so Dewsbury as a place was somewhere where you would go to consult with the elders. But, we said, you must not conflate Dewsbury the place with the Dewsbury Trust. The Dewsbury Trust, we said, was simply a local trust, or a mostly local trust. It came into being in 1975 when the property in Dewsbury was acquired. It held that property and maintained it along with Christian Street in London. That was all it was. The LBMW defence, on the other hand, they said you should conflate the two. And this was a critical point dividing. They said they were synonymous. Now, if I can just show you my closing submissions on this. It's Supplemental Bundle, tab 162, page 714.
Sorry, Supplemental Bundle.
I don't have numbered bundles. It's tabs 162. It's going to be very inconvenient, I'm afraid, but
It's the third one.
try and find out before you know how they divide up, so I can tell you. Can I just ask you to read very briefly my paragraph 132? It's on page 714. It goes over onto the following page. My closing submissions. So that was our closing. The LBMW defendants did not deal with it in their written document, but it came up orally. And if you have the transcript bundle, which I think is your bundle 4, and go to tab 173, page 1003.
1003.
3. So this is Mr. Westwood's closing submission. And if we look at internal page 975, starting at line 7, Mr. Westwood said this: "My Lord, we invite the court to infer that the donors and lenders intended to give money to the existing Tablighi Jamaat movement, headquartered in Dewsbury, so that Abbey Mills would be held on the same basis by the same institution as Crispin Street." Judge Cadwallader, this is where I find myself tripping up quite a bit, because the elision of the movement with the trust is something which causes me some concern. I wonder how you say I ought to approach that potential distinction. And he then says, well, I'll come back to that later. And where he comes back to it later is on page 1008. It's internal page 994. Line 9. And he says, "My Lord, the first was the point about the elision of the movement with the Dewsbury Trust. How you should approach that potential distinction is how it was put, I think. My Lord, in our submission, the answer to that is straightforward, in the sense that it's our submission, my Lord, that at least until the split in 2017, the UK movement and the Dewsbury organisation were synonymous." Judge, okay. Dewsbury organisation, Dewsbury Charitable Trust, my Lord. I see. Mr. Westwood, one can see that in the name of the Dewsbury Trust, the Anjuman-e-Muslimin of the United Kingdom, which makes it clear on its face in our submission that it is meant to be the national legal entity for the movement. My Lord, the Dewsbury Trust as well, and we looked at this to an extent yesterday, does envisage that more properties will be acquired by the Dewsbury Trust, or may be acquired by the Dewsbury Trust. So their positions, well, because it called itself Anjuman-e-Muslimin of the UK, that meant it was an overarching national institution, and that the trustee had power to acquire other properties, and that as it were, reinforced the point. Now, the judge did not accept Mr. Westwood's approach. At paragraph 46, to which Mr. Loveday's skeleton relies, is a passage where the judge is addressing the spiritual hierarchy within the movement. He was not addressing the question of the overarching national institution. And if you see that, it's a core bundle, tab 10, paragraphs 45 and 46 under the heading hierarchy. He's talking there about spiritual hierarchy and its cultural consequences. If you then go forward to paragraph 55 of his judgment, on page 141, here is where he addresses Mr. Westwood's submission about the name of the Dewsbury Trust.
Sorry, paragraph
155 on page 141.
Yeah.
He says the name of the society is a reference to the Tablighi Jamaat in general. Mohammed, that's the founder of the movement, called it the Reformation of Faith of the Muslims, Islam Muslimin. This effort is commonly known across the world as Tabligh, and the meaning of Jamaat is group, hence Tablighi Jamaat. I attribute no particular importance to this name, or to the names with which the Dewsbury Trust has since been registered, in considering whether the Dewsbury Trust is merely local or not. And then in paragraph 56, he responds to my submission that it's a purely local trust. And if you just remind yourself of what he says there, he says he broadly accepts that submission, although he says it is slightly more nuanced because there is a power to acquire further property. Finally, my Lord, could you just look at paragraph 61 on page 144, where he says, a distinction needs to be made, which was not always made by the parties or the witnesses, between the Dewsbury Trust and its trustees, that's on the one hand, and the Dewsbury Tablighi Jamaat elders and leadership, and that's on the other hand.
At 56, he's dealing with the position in 1975, isn't he? When it came into existence.
He is. That's correct. But I submit he's also making the general point that you're not to conflate these two.
But the concept of it capable of expanding nationally was a concept which existed in 1975. What he doesn't say there is whether or not it had expanded nationally.
No, he doesn't. But that's something he comes on to later in the judgment, which I will deal with in due course. And then finally, on this, Lord, you go to paragraph 70, begins at page 148. This summarises his conclusions based on the evidence that he's looked at up to this point. And if you look particularly at subparagraphs 3 and 4 on page 149, it isn't
Sorry, go on.
one of the grounds of appeal that the judge was wrong not to accept their submission that the Dewsbury Trust was an overarching national.
It isn't.
It isn't their case. They have not appealed on that basis. And so the appeal has to be argued within the four corners of the judge's findings that he didn't accept that case.
You may say this doesn't matter given the submission you've just advanced, but Mr. Holland took us to materials relating to, I think, Blackburn and Leicester.
Yes.
Are they consistent with subparagraph 3?
Absolutely they are, and I will come on to them.
Yes.
And we'll going back to the appellant's skeleton, so this is tab 3 again, page 40, paragraphs 8 and 9. Well, paragraph 8 is I may put it this way, it's a tendentious way of formulating the issue the judge had to decide. It is not the way the issue was formulated for the judge in the agreed list of issues. And paragraph 9 invites you to...
Do we have the agreed list of issues?
We do, and I'm going to go to it in 1 second if I may. But before I do, can I just point to the second sentence of paragraph 9, which purports to provide a key piece of context, which is, it is asserted, that all parties agreed the site must be preserved and used primarily by, and for the benefit of the London community of Tablighi Jamaat followers. And I'd ask you just to keep that assertion in mind in what I show you next. The list of issues is at tab 22 of the same volume. Issue 1 is, as it were, open-ended. What's the objective intention? And issue 2 then sets out the two competing conclusions that he was invited to, either A, which was my case, or B, which was the appellant's case. And, my lord, it's important to note that there are two differences between these two competing positions. The first difference is the charitable purpose. But there's a second difference, which is my Lord Justice Arnold this morning. It's control. Who was going to be in control of the money and in control of the land that the money was used to purchase. Now, so far as the purpose is concerned, we said the intention of the donors and the charitable purpose for which the monies were held on trust was not about benefiting the Tablighi Jamaat movement in the UK generally. We said it was about benefiting the local community. The aims were local, not national. The appellants did not agree about that. This is one of the respects in which the appeal has proceeded on a false premise. The pleadings are in the core bundle, and the particulars of claim are at tab 16. My lords, if I could just ask you to read paragraph 2. So this is our case.
I think I'm in the wrong place, sorry.
So tab 16, core bundle tab 16.
Yes.
Should be
yes,
particulars the
sorry.
same, we amend.
Yes. I'm with you.
If you just read paragraph 2, please. So we said the purpose was to acquire and maintain the mosque and the land for the use and benefit of the Sunni Muslim community in London, associated with the Tablighi Jamaat movement and historically centred on Christian Street. Well, the defence begins at tab 18, 258, and if you go on to page 259 to paragraph 4, say that it is admitted that the building on the land is used as a mosque or a community centre. Paragraph 2 is denied. So there is a denial that the purpose we pleaded out in paragraph 2 is the purpose for which the land was acquired. You will see subparagraph 8 is a verb that the land is and has at all material times been held by the first and second claims of the 40% on trust for charity 505-732. Look at Roman numerals 1 and 2 under particulars. So the purchase price is provided by or on behalf of that charity, and for reasons presently unknown, on the acquisition of the land by that charity, title is transferred to C1, C2 and D14. So their case is simply, this is just the dues of the trust buying the land with its own money. If you then go on to page 262.
Well, and as I observed earlier, the absence of any explanation as to, or case as to why title was registered and named as C1, C2 and D14.
And if I may, I'll come back to that as well, because there is a shift in the evidence when the witness statements come out on that point. Page 262, subparagraph C. The spirit of the various contributions to acquire the land is principally to be found in the stated purpose of charity 505-732. Moreover, the context demonstrates the expectation and understanding of the donors and members that generally, 1, that the land would be acquired by and managed on behalf of and under the direction of charity 505-732, and all those leading the Tablighi Jamaat community in Dewsbury, in accordance with the long-standing structure of the Tablighi Jamaat community in the UK, and 2, to be used by that charity and or under its direction to provide a flagship centre for worship and missionary work for the Tablighi Jamaat movement across the United Kingdom and or Europe, brackets, as well as secondarily supporting the Tablighi Jamaat and wider community in London. So it was not their case before the judge that the intention was to buy the land to provide and maintain a mosque for the London community. The London community get a secondary look in parentheses, that this was supposed to be, on their case, a national flagship centre. And finally, therefore, subparagraph D, they deny that the spirit of the gifts is as it was alleged in paragraph 2 of the particulars of the claim. This position was maintained through the case to the closings, and the relevant part of my closings is tab 162. I suspect it's probably bundle 3, I guess. And it's paragraph 142.
Sorry, page number of the bundle.
Sorry, 720.
Thank you.
Page 142. So I'm simply repeating the case that we had pleaded. So far as the defendants are concerned, it's tab 163. It's the following tab, and it's page 766. And it is the first sentence of paragraph 15. They say the LBMW defendants have never disputed that Abbey Mills ought, to a significant degree, to be serving the London community, local community in London, alongside its role as a centre for the UK and Europe more widely. And I sense them inching away from their original pleaded position, but not actually conceding it. Similar. If we go back to Mr. Loveday's skeleton, which is the core binding tab 3, where he says in paragraph 9, all parties agree that the site must be preserved and used primarily by and for the benefit of the London community of the Jamaat followers. That is simply not true. It was not agreed. It was not the case put before the judge. And it is quite wrong to approach this appeal on the basis that what is said there represents the position as presented and argued at trial. So that's purpose. So far as control is concerned, our case was that the intention was for C1, C2 and D14 to hold the funds and then to hold the land for the charitable purposes we have identified. C1, C2 and D14 are, of course, all members of the London community, and therefore the fund and the land would be controlled by trustees who were members of the community that the fund and the land was intended to benefit.
There's nothing in the trust deed, is there, about benefiting London, the London community?
No, there isn't. There isn't. And it might have been said, well, there was a Matheson argument here. I mean, our case was, once the funds have been donated or left, there is a charitable trust imposed on them. And it might have been said, well, look, when you declared the 1996 trust deed, that had to be consistent with the charitable purposes. And if you declared it too widely, as it were, that might have been said to be out with the Matheson principle. But that case was never run, in the sense because it was academic. I mean, we said, and the judge accepted, and I think the other side accepted, but really, once you get to the end of issue 2, that's kind of the end of the case. What happens with the trustee is really neither here nor there at that point. The appellant's case was for the money not to be held by members of the London community, instead to be held by the trustees of the Dewsbury Trust. I've shown you that paragraph in their defence already, where they said the understanding, the expectation is for land to be acquired by and managed on behalf of and under the direction of 505732. And consistent with that, if one goes back to their defence, that there is a counterclaim for an order that the first and second claimants do join in the court of the defendant in executing a transfer of the title to the then Dewsbury trustees. That's on page 268. And until 2020...
Sorry, can I just find that?
Sorry, page 268,
Yes, I see.
paragraph 2 of the prayer. Until 2020, all of the trustees, apart from D14, were based in Yorkshire. The judge finds that at paragraph 66 of the judgment. And under the trust deed, the 1975 trust deed, that is, it was those trustees who would have the power to appoint replacements. That's clause 10 of that trust deed. So our case was control would rest with members of the London community. Their case was control would rest with the trustees of the Dewsbury Trust, who would then be able to control their successors. So we were divided about these two things, these two related things, purpose on the one hand and control on the other. And the judge was alive to the fact that both those things mattered. And can I just show you this very important paragraph of this judgment? The core bundle again, at 10. Page 149. And it's paragraph 71. It says, taking into account the totality of the evidence, I find there would have been an expectation at the relevant time on the part of both the fundraisers for and the potential donors to the acquisition of property for a Marquez in the UK. I should say, he's talking generally about any fundraising, not specifically about London. That it could not be held on terms which might allow it to be devoted to purposes which excluded primary use and at least a high degree of control by local members of TJ, unless the contrary had been spelt out. The expectation would be that if bought by locals, it would be used for and controlled by locals. That is not necessarily the same as an expectation about ownership. It tends to point towards an intention that there should be local ownership on local terms. Now, there he's talking about just the obligatory market movement generally and what the expectation would have been within it. But there was also an additional point which was specific to the relationship between the London community and the Dewsbury community, or Dewsbury Trust, which is that there was evidence of a tension between the two, and the tension related to finances. It is addressed in the judgment at page 154 of the bundle, and it's paragraphs 83 to 85. I just ask you to remind yourselves of what's said there. So there is the account of the £100,000. There are £200,000 in this case, I should say. There's the later one. This is quite separate. And the tension that had generated. Now, you see evidence of the existence of that tension in in a contemporary document, which is at tab 114 of the supplementary bundle. It should be bundle 2. And page 471. 471 is a letter Mr. Isaac, the solicitor, wrote to Mr. Mohammed in 1999. Because I thought I'd just let you know, I had a telephone conversation last week with Adrian Salt. He feels fairly easy deal with land registry queries on boundaries.
Sorry, who is Mr. Salt?
I think he was a boundary surveyor. That part of the letter is not relevant. It's this next paragraph. I've had another letter from Mrs. Chadwick Lawrence, those are solicitors instructed by the Dewsbury Trust, up north, asking the current position. I should make some response to that. What would you wish me to say? And the next tab you'll find Mr. Mohammed's response to that letter. Dear Mr. Isaacs, thank you for your letter. Very much disturbing, where the community already threatens that they will take legal action if transfer are made to anyone except the people in London. There was evidence of this tension in some of the oral evidence too. You could take up the transcript bundle, so it's volume 4, tab 167, page 881. And this is the cross-examination of Yaqub Ali Mohammed. He was one of my witnesses, but by Mr. Westwood. And if one looks at internal page 343, starting at line 17, were you aware in 1996 that Christian Street was owned by the Dewsbury Trust? Yes. When you made your donation, were you told at any time that the new site was going to be independent from Dewsbury? Yes, I was informed. And who told you that? The committee members, because I asked the position before I donated payment. Which committee members told you that? If I remember correctly, Mr. Sokat and other people. Did they tell you that they were establishing a new charity? No. Did you ever see a new charitable trust deed? No, I do not have that knowledge at that time. No. Question. What I'm going to suggest to you, Mr. Mohammed, is that nobody told you that Abbey Mills was going to be independent from Dewsbury. Do you accept that? Answer. No. I asked them if this new market, the new place that we're buying, will there be any connection with Dewsbury? They said it's totally independent. On that basis, I've donated £1,000 for myself. So, what we have is the judge is finding the general expectation within the Tablighi Jamaat community about how local properties will be held, and particular reasons why the London community may not have wanted the property to be held by the Dewsbury Trust. Now, the final point to mention on the issues the judge had to decide is what's meant by the objective nature of the exercise. Well, it's objective in the sense that the question is what would a reasonable person conclude about the intention of the donors. If we were answering that question by trying to construe a written instrument, then evidence about what subjectively donors had intended or believed would of course be irrelevant, inadmissible. But we're not construing a written instrument. There is no deed of settlement. And because we're not construing a written instrument, evidence of subjective intention is relevant. It's not determinative in the sense that the judge can say, well, I know you say that, but I don't believe you, frankly, or objectively, although you say that, that's not how I see it. But it is certainly admissible and it is certainly relevant. Carmichael, of course, is the main case, but the point is most shortly expressed in McCarthy and Jones, which is in the authorities bundle tab 8, and it's paragraph 17, where a contract is contained in a written document, documents interpreted without regard to the parties' subjective understanding of what they've agreed, where by contrast the alleged contract is oral, then the parties' subjective understanding is admissible, at least to the extent of deciding whether the parties reached a concluded agreement, and if so, what were its terms.
Do you not need Carmichael to flesh that out a bit?
Well, sure. It's tab 1. And the relevant passages, they are in fact the passages that have been highlighted. So it's 2048, letter D, 2049D. And then more importantly, 2050 at E2, the bottom of the page.
And as you say, it's 2050 that's
2050,
more helpful, probably.
And in a sense, we both approach the case that way. I mean, Mr. Holland relies on things that Mr. Mohammed said in letters. What are they? Well, that's just evidence of Mr. Mohammed's contemporary subjective understandings and belief. I don't think in practice we actually do anything very different. It's just that on the appeal, the complaint is made repeatedly, oh, well, you're crossing the line. But my lord, we're not. Well, that completes part 2 of my submissions. Part 3, I'm afraid, is a little longer, which is the survey of the evidence. And the way I'm going to do it is to address it in the way that the judge did, which is to deal chronologically. Because if you jump around, you risk confusing yourself or misleading yourself about what documents signify. The judge started, and rightly so, with the Tablighi Jamaat movement generally. What was it? And the first important point to understand about it is that it is enormous. I will confess, I had never heard of it before this trial. It keeps a low profile, but it is said to be the largest Islamic movement in the world. One of the documents in the bundle, I'll give you a reference for it. It's tab 146, page 562 to 3. You don't need to go to it, but it says that the membership is estimated at between 100 and 150 million people worldwide. The fact that this is such a vast movement, and it's a missionary movement as well, it aims to recruit, So it's a vast and growing movement. And that is very important, to place everything else into context. What we said about this in our closing, it's your volume 3, tab 162. Page 717, please. And could I just ask you to read paragraph 134? And if you just read the whole of that paragraph, if you wouldn't mind. The second point about the movement is it came to the UK in the 1940s. Started in India in the 1920s, but by the 1940s there was a Tablighi Jamaat community in London, and the first community in the UK was in London. And what that meant is that Tablighi Jamaat as a movement had existed in the UK for 30 years or more before the Dewsbury Trust was even created. And that was important contextually because it meant that the movement in the UK did not begin, as it were, with the creation of an overarching national institution, as it's repeatedly described.
I can't remember what the judge says about this. The trust comes into being in the mid-1970s. Is that when the Dewsbury presence arises, or is that earlier? Is it just documented later, or is it?
It's not clear. I think that there must have been a community in Dewsbury before the trust, because the trust was created on the day that the land in Saviltown was acquired. And one must assume that the reason why they acquired the land was because there was a community in Dewsbury. So it must be the case that the community existed before then, but there's no evidence as to when it started. But staying on that point, what one can see from the trust deed is that the trust came into being for a very specific and very local reason. It was no part of the creation of the trust purpose that, right, we are creating a national institution here. It came into existence to declare the trust on which the land was going to be held.
But as we explored earlier...
There is a nuance to it, yes, of course, exactly. But can I just... It is only a nuance. Because if we can just go to the Declaration of Trust itself, it's tab 22, so that's your supplemental one.
Are we coming back to your closing submissions? Or
Not at the moment, no. Now, if you look at the front page of this, so page 216, you see the heading. It says, the Madrasa Talim ul Islam, Saviltown, Dewsbury. Now that is the name of the madrasa that was opened on the site. And I think you've seen the recitals already, but they recite the conveyance, which is dated the same day. They recite the reason for purchasing the land, and they recite the reason for the declaration, except there is a contemplation of further property perhaps being added. And can we just go from there, please, to a set of the accounts? And so you can close that up. Well, it's the same bundle. Oh, no, it's not. Sorry, close that bundle, supplemental bundle 3.
am I not going back to the Declaration of Trust?
Not at the moment. So it's tab 160, page 637. And these are some much later. So these are 45 years after the Declaration of Trust. These are the 2020 accounts. And if you go to page 639, down towards the bottom of the page, you have name and governing document. The governing document of the charity is a Declaration of Trust and Constitution, 25th of June 1975. The charity is also referred to as the Markazi Masjid and or Jamia Talimul Islam. Markazi Masjid was the name of the mosque in Dewsbury. Jamia Talimul Islam is the name of the associated madrasa. So the naming, the trust is known, as it were, interchangeably by the names of the buildings in Dewsbury.
Can we just look at that again? Charity is also referred to as the Markazi Masjid.
Yes.
I sort of half remember Masjid probably means mosque, does it?
Does. And Markazi it means centre. But Markazi Masjid in this collocation is what the mosque in Dewsbury was called. It's called the Markazi Masjid. And Jamia Talimul Islam is the name of the madrasa. And can I just show you the evidence on that, just to make my point good? It's in your transcript bundle, volume 4. And it's tab 169, it's page 932. Sorry. And if you have it's internal page 552. It's my cross-examination, Mr. Daji. He's one of the trustees of the Dewsbury Trust, and I'm looking at the accounts. And if you look at line 11, I said, in the charity is also referred to as the Markazi Masjid and or Jamia Talimul Islam. Do you see that? Markazi Masjid, that's the name of the Dewsbury Mosque. Mosque, yes. You mentioned a few minutes ago a school, that's the boarding school, yes. That was based at the madrasa on South Street. Jamia Talimul Islam, sorry. Jamia Talimul Islam, yes, that's what I was getting at. The name of the school was Jamia Talimul Islam, yes. So those are the names of the buildings in Dewsbury. And what you will see when we come on to it is that Tablighi Jamaat trusts tended to be named after buildings. They tended to be trusts of an individual building, and they tended to have a name that was interchangeable with that building. If one goes back then to the 2020 accounts that we were looking at, we looked at name and governing document. If you look at the next paragraph, it says Principal Office.
Sorry, remember the page again.
Sorry, it's on page 639. These are the 2020 accounts again. We looked at name and governing document. Next up is Principal Office. It says the Principal Office and indeed the major operations of the Anjuman. Anjuman means society. Are situated at South Street, Seltown, Dewsbury, West Yorkshire. What it does not say is the Anjuman is the national organisation for Tablighi Jamaat and has operations across the UK.
Just talking about terminology. The judge obviously refers to the London Shura. I'm not sure he ever defines London Shura.
No.
Don't come to it now.
Sure.
I wouldn't mind some explanation of what it would signify.
Well, I can tell you very briefly, I'm not sure where the evidence is on it, but I'll see if I can find it overnight. Shura simply means council. And within each community, there would be a shura, which is the council of the elders of that community. So there is a Dewsbury shura, there is a London shura, there's a shura in Nizamuddin. There is what we call, on our side of the schism, a world shura. But shura itself refers to a council of elders within the movement. Does that help? Now, just while we're on these 2020 accounts, could you go forward, please, to page 645? That's the charity equivalent of what I think of as an income and expenditure account. Mr. Daji, who I cross-examined, was the trustee who signed off these accounts. You see his signature on page 646. And the short point to make about this is that all of the expenditure you see here was local expenditure connected with Dewsbury. And the vast majority of it, as you'll see, is salaries, 496,688. That those were the salaries of the teachers at the madrasa. The other important piece of evidence about the Dewsbury Trust was its relationship with the international movement and with Nizamuddin, which at this time was where the global leadership of the movement was located. Now, the evidence that the defendants, the appellants, led was that the relationship was like that of the holding company and the subsidiary. And I'll just show you that if I may. It's your first supplemental bundle. Sorry, you can put away the accounts, I should say. First supplemental bundle, and it is tab 17. Page 175. This is one of the defendant's witnesses, Mr. Bedeker. And paragraph 6, he says, since the work of Tablighi Jamaat is spread across the world, it's impossible for Nizamuddin Markaz to be overlooking the affairs of every country on a day-to-day basis. Hence, like any corporate organisational structure, they have formed subsidiaries to act as Markaz in their respective geographical continents. Now that characterisation, that assertion, was false, as Mr. Daji accepted. And let me just show you the judge's conclusion on this. It's his judgment in the core bundle, it's tab 10, page 144, paragraph 62.
Paragraph
62. And what we said is that relationship between Dewsbury and Nizamuddin provided you with an analogue, as it were, for the relationship between Dewsbury as a community, as a trust, and the local communities in the UK. So that takes you to the end of the judge's section of the judgment dealing with Tablighi Jamaat and its history. The next section, which begins at paragraph 63 and goes on to 73, deals with the relationship between Dewsbury and other UK centres. Now, there are large and small communities across the country. The large communities are London, Dewsbury, Leicester, Birmingham, Blackburn, and Glasgow. And what we looked at in the evidence, and what the judge looked at in particular, was how are local communities funded, and how did they hold property? Where funding is concerned, there are two elements to it. How did they fund their day-to-day operational expenses? And when they acquired property, where did the money come from? In terms of day-to-day funding, it was clear that local communities funded themselves. There was no top-down funding from Dewsbury. Local communities simply looked after their own needs. That was evident from the Dewsbury Trust's accounts. It was evident in the cross-examination of Mr. Daji. And I won't take the cross-examination, I'll just show you the passage of the judge's judgment where he deals with this. It's page 146. It's paragraph 66. That was the top sort of 8 or 9 lines. In terms of where money came from for the acquisition of property, this was more contentious. It involved some extensive cross-examination of Mr. Daji, and if you want the reference, I won't show you that section of the transcript, but if you want the references to it, they're in my closing at paragraph 25. And the judge made a finding of fact about that at paragraph 68 of his judgment, on page 147. And again, it's the first 5 or 6 lines.
Sorry, I must give you up again. Which paragraph?
Sorry, page 147, paragraph 68.
Yes.
So where he had got to at this point is that local communities were financially independent, both in the sense that they funded their own day-to-day activities and they funded their own property acquisition costs. He then moved on to property ownership. And the position here was that there were markazes for Jamaat mosques in each of those locations I've described. And we knew from the previous findings that the funds to acquire those properties had been raised either entirely or mostly from within the local communities that they serve, not from elsewhere. Purchase price not provided by the Dewsbury Trust. The question then is how are those properties owned? And can I just deal here first with a preliminary objection? So the appellants say in paragraph 77.2.2 of their skeleton, we'll just take that up quickly. It's tab 3 of the core bundle, page 59. They said these properties were not the subject of any pleaded dispute. Rather, the claimants served witness statements about them as similar fact evidence, including serious allegations of forgery. The LBMW defendants did not serve their own evidence on these properties because they were outside the scope of the pleadings, nor was any disclosure sought or given in relation to them. So, in effect, they're saying, well, it was unfair. The judge shouldn't have gone there. Now, well, the factual premise for that is simply wrong because both sides led evidence about this. And the claim by the appellants that they didn't is untrue. I can show you that in the first volume of the supplemental bundle, tab 19, page 188. So this is one of the defendant's witnesses, Mohammed. Paragraph 7, the Dewsbury Trust covers the UK, and therefore I understood that the site would benefit members of the TTA from the London community, UK and Europe. The Dewsbury Trust Markaz is the Markaz with the main leadership in the UK. It's the parent Markaz. Markaz based on the Abbey Mills site must be a child Markaz. Paragraph 9, C1, C2 and D14 work locally under the instructions of the Dewsbury Trust. My understanding is that the Abbey Mills site was held by the trustees of the Dewsbury Trust. I was not aware of a transfer of the ownership. 10. There are many sites across the UK, such as Blackburn and Birmingham, and all of these were owned by the Dewsbury Trust. It's my view the London community wants to be under the ownership of the Dewsbury Trust. So there was evidence on both sides about the nature of property ownership within the movement in the UK. The main evidence about it came in the form of the Dewsbury Trust's accounts. And what we had was accounts that spanned a 26-year period. And we didn't have all of them because some of them had supposedly been lost. And throughout that entire period, from the earliest account to the latest, Mr. Daji was one of the trustees of the Dewsbury Trust. He was the one who signed off all of the accounts, and he gave evidence. And the Dewsbury Trust accounts contained a balance sheet, which each year provided a figure for the fixed assets held by the trust. And if you worked through the accounts chronologically, you could identify precisely how the figure on the balance sheet was made up, even though you lacked a few years here and there, but you could piece it together. And with the exception of 1 year when Abbey Mills popped on and then popped straight off again, the balance sheet only ever contained the Dewsbury properties and the property in Christie. And I cross-examined Mr. Daji about this at some length. If you could take up the transcript bundle, so bundle 4. I'm not going to force you to read all of it, but I'll tell you where it starts and where it ends. It starts, it's in tab 168. Page 925, internal page 528, line 3. That's where I start to walk through the accounts with you. But where we need to end up is if you go forward to page 932, and I want to look at internal page 553. This is my cross-examination of Mr. Daji. Those accounts that we've been looking at, they span a period of 26 years, yes. Started in 95, ended up in 2021, yes. They're public accounts that you file. Sorry.
Oh, yes, I see. Yeah, I'm with you. Yeah.
They're public accounts that you file with the Charity Commission, yes. Except for 1 year in which the Abbey Mills properties added to the balance sheet only to be taken off it again. The only properties that ever appear on the balance sheet are the Dewsbury Mosque and the Drassa, yes. And the Christian Street property, yes. Fixed assets don't include the Marquez in Glasgow. Do you agree? Sorry. It's a question. Fixed assets do not include the Marquez in Glasgow. Do you agree? No, yes. Do you agree they don't include the Leicester Marquez? No, it does not include. Or the Birmingham Marquez? No. Or the Blackburn Marquez? No. Except for 1996, they didn't include Abbey Mills either, yes. And that is because those properties do not belong to the Dewsbury Trust. Do you agree? Yes. When we purchased Abbey Mills, you see, it was a big project. I think you're answering a different question. The question I asked you, we run through these properties, Glasgow, Leicester, Birmingham, Blackburn, Abbey Mills. The reason why those properties do not feature on the balance sheet of the Dewsbury Trust is because they do not belong to the Dewsbury Trust. They've never been included. They've never been included. And the reason they've never been included is because they do not belong to the Dewsbury Trust. Answer, yes. And I gave him a second chance. I said, yes. He confirmed, yes.
He seems to row back a bit from that in the following page.
He does row back in subsequent. I agree. But that was nonetheless that direct evidence from one of the trustees in which, before he later came to appreciate that it was an unwise concession for his case, he accepted that the Dewsbury Trust did not own those other properties. And, before I'll come on and address some of the documentation that Mr. Holland mentioned. Can I, just before I do, make this, that the judge made his findings about this at paragraph 66 of his judgment. And what he held was that the Dewsbury Trust did not own other properties around the UK apart from Abbey Mills and Christian Street. That's paragraph 66 of the judgment. When permission for this appeal was sought, it was sought on the back of a skeleton argument that you find at tab 2. And the permission skeleton at tab 2 complained about the judge's treatment of the receipts, about the judge's treatment of the holding out evidence, and about the judge's treatment of the 1994 meeting. It said nothing about the judge's treatment of the Dewsbury Trust's accounts, or about his findings about property ownership within the movement across the UK. Permission was then granted by Lady Justice Falk. And permission is at tab 11 of the core Bible. She explains why she's granting permission, and then she says about halfway down the reasons box, she says, however, the appellants will still need to address other evidence that the judge took into account, such as the Dewsbury Trust accounts and evidence as to how TJ properties elsewhere are owned. Now, what she was saying, I suggest, was that okay, you've got your 3 grounds of appeal, but the way you're going to have to run this appeal is explain why, notwithstanding the judge's findings about property ownership and the accounts, nonetheless your complaints are sufficient to, as it were, cause his judgment to be overturned. That is not how the appellants treated her permission. What they did was to put in their substantive skeleton of the appeal, which had a new section bolted onto the end of it. And the new section is a section at pages 58 onwards, under the heading Other Matters Taken into Account by the Judge, where they complain about the judge's treatment of the accounts and complain about the judge's treatment of Daji Jamaat properties elsewhere in the UK. Now, Lord, there is no permission to pursue those points on this appeal. Lady Justice Farrell,
is that fair? I mean, you're absolutely right to say that they're not independent grounds for appeal, but surely the appellants are entitled to say why these points made by the judge don't sufficiently answer the points that they are relying on in their grounds.
well, if it was, I accept that to a degree. If what they were doing was saying, well, the judge made a finding in respect of ownership of property, but notwithstanding that finding, that didn't outweigh our position. They can do that, absolutely.
Yeah.
But
What you say is they can't attack
Exactly.
the other finding.
Exactly. They can't attack the factual findings the judge has made about these things. And the point I make, I mean, the primary evidence for it is Mr. Daji's cross-examination, but the judge has made findings about the ownership of properties within the movement across the UK, and they're not entitled, we say, to challenge that. Lord, if I am wrong about that, let me just look briefly at the underlying documents. If you close up the core bundle and take up supplemental bundle 3, and go to tab 149, page 592. This is the transfer of the Birmingham Mosque. And you'll see that it's a transfer from Birmingham City Council to Hafiz Patel, Mohammed Qureshi and Mohammed Hansrock. Now those 3 individuals are 3 of the trustees of Dewsbury Trust. And it says they are described as being all of the Markazi Mosque, South Street, Sallingham, Dewsbury, West Yorkshire. But then, see what the next sentence is. 3 of the trustees of the Zacaroli Mosque Trust. And if you go forward to clause 3 on page 596, you'll see that the transferees hereby declare that they shall stand possessed of land hereby transferred upon trust, sell the same or any part thereof, etc., as part of the assets of the Zacaroli Mosque Trust, and in accordance with the rights of the trustees for the time being of the said Zacaroli Mosque Trust. Now, I said earlier that the Daji Jamaat trusts are often known after the name of the property to which they relate. And I want to come back to that transfer, but if you just put that to one side and take up the transcript bundle, so bundle 4 once more, go to tab 169, page 937. Internal page 572. This is my cross-examination of Mr. Daji about this transfer. I said, do you see that it then says you are the trustees of the Zacaroli Mosque Trust? Yes. Is the Zacaroli Mosque another name for the Markaz in Birmingham, it is the name of the mosque. The name of the mosque in Birmingham, yes. So the Zacaroli Mosque is the name of the mosque in Birmingham. The Zacaroli Mosque Trust clearly relates in some way to that property. There followed some lengthy and frankly tedious attempt by me to elicit from Mr. Daji what the Zacaroli Mosque Trust was exactly and what its terms were, but nothing whatsoever was forthcoming. And if we just go back to the transfer, the point on which Mr. Loveday relies on the skeleton is if you go over to page 597, what you'll see at the top of the page there is a clause 5. Now what clause 5 appears to state is that the land that's being transferred by this transfer will be held on trust for the Anjuman al-Islam Muslimin Madrasa Talim ul-Islam charity. So that is the Dewsbury Trust, remember, because the Madrasa Talim ul-Islam is the name of the madrasa in Dewsbury. So what you have is a document in which, on the first page and in the main terms of the document, you have the transferees being described as trustees of the Zacaroli Mosque Trust. You have an express declaration that they hold the land on trust for the Zacaroli Mosque Trust. And then you have another apparent declaration at the top of the last page that they hold it for the Dewsbury Trust. And the striking thing about that last clause is that it's obviously been typed using a different typewriter, and it's obviously been squeezed into a gap at the top of the page. And we said that although you couldn't necessarily make any conclusive finding, if this were a litigation directly about the ownership of this land, in which the ownership of this land was the issue, you would need some further evidence clearly. But the impression given by that provision is that somebody has adopted this document. They've typed it in.
I mean, I can see at 592 a land registry stamp.
Yes.
Do we, I mean, if they received the whole of what we see at this tab, then any conceivable doctoring would have happened by 1994.
It may have done. I'm afraid what I don't know is where. Yes, I mean,
which would be
I
roughly
can't
the
tell
date
you
of-
exactly the route that the document took to get to us.
I mean, yes. I mean, if it's been doctored subsequently, that's one thing. But if the land registry received on the 25th of May something dated the 10th of May, including this extra bit, then it looks very genuine.
And what, sorry?
Then it looks very genuine. I mean, so be it was probably added later, but
Codes on the barcodes don't seem to match.
did they not?
For what that may be worth, I have no idea.
Anyway, the real question, I mean, if I can put it this way, the question was, given Mr. Daji's evidence about the Dewsbury Trust, given the state of the Dewsbury Trust's accounts, did this transfer, as it were, pull the rug from underneath the answers I got in cross-examination, or did it, frankly, not advance the appellant's case very far? And the answer we suggest is the latter. My lords, I see the time.
Yes.
This would be a convenient moment.
And can I just check, do you think you're on target? I think under Mr. Holland's timetable, we would finish by about 12:30.
Yes.
Good. In which case, 10:30 tomorrow.
Judge Exeter.